How will states implement the idea of a World Investment Court? Does the investment court envisage that states will opt into this mechanism at their own selection in BITs, or would they be offered a multilateral convention for ratification?
Right. Well, by its nature, the only way in which such a court could apply, if you think about transparency, what we did was twofold. One, we amended the antitrust rules on arbitration to append to those rules the antitrust rules on transparency when it came to investor-state arbitration. But that only applies prospectively. So if you have a new BIT, you incorporate the arbitration rules with it as part of the option under antitrust arbitration, and that brings in the rules on transparency, but prospectively. The only thing which you can do going back in time is by using the Article 30 mechanism, which is saying, well, I've now got a new multilateral convention which is changing the offer of confidential arbitration into an offer of transparent arbitration. Now, obviously, that has to be done by way of a multilateral convention. So that, I think, contains the answer to your question. It necessarily is an opt-in, and it will necessarily be by way of a new multilateral convention. I don't think anyone has come up with any other solution at the moment. And I think it's the right thing too, because it is quite a big step. And it should be by way of an opt-in. And I'm very hopeful that this should answer a lot of the questions or criticisms by states that would not want to be part of that system, because no one can impose it on anyone. It would be purely opt-in, and whatever antitrust does itself would have no normative power whatsoever. All that would end up, the result of the work would be a draft convention, a convention, which would be open for ratification, and then states are free to adopt it or not.
What role does human rights play in investor-state relationship? And to be precise, do present-day BITs contemplate human rights or commercial rights relating to investor and states? And do we need additional provisions in BITs to preserve state regulatory powers? What is your take?
I think traditionally people have compartmentalized international law. Often it's called fragmentation. You get people who will focus on investor-state. You get people who focus on environmental law, and you get people who focus on human rights. What has come to light, at least in my view, over the years, is that fragmentation actually is not correct. It's not a correct analysis, because you have intertwining obligations. So any state that takes on international obligations by way of an investor-state treaty can't thereby blot out its existing obligations under international human rights law, for example, or environmental law. So you've got a combination of obligations, but more specifically, what we are now seeing increasingly is a direct impact of human rights in a number of aspects of BIT practice and interpretation, BIT law. And you can divide it really on the state side and on the investor side. So on the state side, states will frequently present a defense which has in it their own separate obligations with respect to human rights. It may also have separate obligations with respect to environmental law or other international norms. So a state will say, I'm entitled to take this particular conduct. You can't criticize me under an investor-state treaty because I'm bound to do it in order to protect human rights. That's often how human rights have been seen as relevant. And you can see that in many cases. I mean, for example, if I think of cases that I've done, I often come back to the same case some years ago, which is Bywater, Tanzania. A very, very classic configuration for a treaty case with a foreign investor who comes in a program for privatization of water supply. Now that can be viewed coldly as a dispute between a contractor and a state over a concession agreement. Or you can view it as a dispute that actually impacts potentially on 350,000 water users in Dar es Salaam and their right to water. That's all on the state side. Now what we're seeing is human rights being deployed by investors. And there are a number of cases, some very well known, some less known at the moment, where investors are actually arguing that human rights gives information and detail, it populates concepts such as fair and equitable treatment, or indeed other guarantees within a treaty. So one example of that would be Al Jazeera against Egypt, where these are claims by Al Jazeera with respect to the treatment that they say they've received by the state of Egypt, and they are looking at concepts such as FET through the prism of freedom of the press. So that means human rights actually can crop up all over, and it's not just now a question of saying, well, we've got investor-state principles and we have other principles, because the two are intertwined. You'd asked another question as part of that, which is, do we need more provisions?
Yeah.
And my sense is yes. And I say that because the experience so far, at least again from my perspective, is that tribunals are ill-equipped to deal with these human rights issues. And that is a major problem in the investor-state field.
So when we say corruption pleaded or an issue of corruption coming up as part of a treaty dispute, obviously there can be a situation where the issues of corruption are very much part of the pleadings or very much part of the past correspondence, or which comes across as part of the dispute in itself, or it comes incidentally to the knowledge of the tribunal. In terms of the effect of either the pleading or coming to the knowledge, typically how would a tribunal deal with it? Is it that they take it up on the basis of suo motu because they get that as part of the information that they are getting, or do they have jurisdiction to even go into it, or they just accept it as part of a fact in the pattern, because to get into the aspects as to whether there was a real corruption or not, how much they would have a jurisdiction to even go into it. So if you can give a little idea about how tribunal would react in some of those situations.
I think it's generally acknowledged that in treaty arbitration, as in commercial arbitration, a tribunal has the right, and some would argue even the duty, to investigate corruption, whether or not it is pleaded. Of course, if it's pleaded, then they will have to confront it as an issue. If it's not pleaded, then it becomes much more debatable. But usually in commercial arbitration, it's accepted that a tribunal is no different from a national court, and most national courts have an inherent duty as the guardian of public policy not to allow a corrupt transaction to acquire any positive rights under the law. So from that point of view, there are some people who would argue strongly that an investment treaty tribunal also has the right and arguably the duty to investigate. In terms of case law, there's actually only one clear authority where a tribunal has, on its own motion, actively investigated an act of corruption which was not pleaded. And that is the case of Metal Tech against Uzbekistan, a tribunal chaired by Professor Gabriel Kochman-Kohler, where the tribunal literally took the hearing by the scruff of its neck and called witnesses and ordered them to produce documents because they felt that both parties were not raising the issue of corruption when it was becoming clear to the tribunal at least that corruption was involved. And in that sense, the tribunal actually made investigations on its own and put questions to the witnesses which would not have been put by the council, and eventually making findings of corruption. The reaction to this case is not universal in terms of praise. And some people say, of course, this is a beacon of light and an example for the profession to follow, and others think that this is perhaps the slippery slope because it tends to make the tribunal an investigating party, which then would perhaps make questionable their neutrality.
The topic for our webinar today is novel and I must say intriguing. We will be discussing the concept of bilateral arbitration treaties, a concept visualized and proposed by our very guest expert today, Mr. Gary Bond. Mr. Gary Bond is the chair of the international arbitration practice at Wilmer-Hale LLP. He is an eminent author, an arbitrator, and has participated as a counsel in more than 650 international arbitrations. For the past 20 years, he has been ranked as one of the world's leading international arbitration practitioners. Thank you very much, Mr. Bond, for joining us today.
Thank you so much for having me.
Mr. Bond, you have conceptualized and invited states to adopt a default mechanism for resolving international commercial disputes through arbitration, through the bilateral arbitration treaties, popularly called as the BATs. What is the idea behind a bilateral arbitration treaty?
Thanks for that question, and also thanks for the opportunity to talk about the subject. The idea of bilateral arbitration treaties, or as you rightly abbreviated, BATs, comes from a relative, a cousin or nephew perhaps, which is bilateral investment treaties. The history of bilateral investment treaties, I think, is well known. They were adopted the second half of the last century by states in order to encourage trade and, in particular, investment. The basic concept behind a bilateral investment treaty was that it provided substantive protections to foreign investors, respectively, from the two contracting states, and then, in addition, and very importantly, provided procedural mechanisms to give effect to implement those substantive protections. The procedural mechanisms that provided those protections were a so-called standing offer to arbitrate by each of the two host states. The two host states would promise to arbitrate disputes under the bilateral investment treaty with investors from the other state that was party to the bid. And this standing offer to arbitrate could be accepted by a qualifying foreign investor. The essential purpose of these arbitration mechanisms was to provide an expeditious and even-handed mechanism for resolving investment disputes under the bilateral investment treaty itself, under its substantive protections. The concept of a bilateral arbitration treaty builds on that, learns from that essential concept in bilateral investment treaties. The notion under a bilateral arbitration treaty is that you use the concept of arbitration as a default means of dispute resolution in the commercial context, just as investment arbitration has learned from commercial arbitration. I thought that commercial arbitration could learn from investment arbitration. And so the essential concept of a bilateral arbitration treaty is that if two nationals of the respective treaty states, states A and B, let us say, have a commercial dispute, an international commercial dispute arising out of some sort of cross-border commercial transaction, then the default means of dispute resolution, unless the parties otherwise agreed, would be by international arbitration pursuant to a mechanism laid out in the BAT, laid out in the bilateral arbitration treaty. That would mean that the host state ports, the two ports of states A and B, would refer parties to that arbitration mechanism instead of resolving the commercial dispute, the international commercial disputes themselves. And likewise, at the end of the arbitral process, those two states, the ports in states A and B, would recognize and enforce arbitral awards made pursuant to that mechanism. International arbitration would become the default means of international commercial dispute resolution between nationals of those two states. That's the essential idea of a bilateral arbitration treaty.